Good evening, Crime Talk aficionados. This is Scott Reich, and this is Crime Talk, the most factured and unbiased true crime channel on the internet. Let's get started this evening. Thanks, everyone that's already signed up and joined us this evening. Thank you for doing so. If you haven't done so already, please hit that subscribe button as well as the like button. Now, for our regular viewers, you probably have noticed, hey, Scott is not in the Crime Talk studio. Well, if you watched today's video, you would know that, well, I am south of the border. I am in Mexico. I am in Cabo, San Lucas, and I am here for a birthday gathering of people. A lot of birthdays going on this year, it seems like. As you may recall, last month we were in Turks and Caicos, which was probably the most amazing vacation I've ever had. The water, the beach, the hotel was amazing. This is pretty nice. I'm not going to lie about that at all, because here we have a villa. It sleeps comfortably. There's 10 of us here, and it's gorgeous. It's private, gated. You drive down, you go all the way kind of down the mountain, down to the beach, and bam, you're in the ocean, although the water's not exactly truly amenable for swimming in like it is in Turks and Caicos, but no complaints here. Now, I've been going to do this. The lovely Miss Kristen, also known as TLMK, the lovely Miss Kristen, she is not here. This is kind of a, I guess, guy's trip. Yesterday, we went deep sea fishing, and that's right, the big one got away twice. It was a long day of fishing and nothing there. So the lovely Miss Kristen is at home. I think she's having somewhat of a gathering herself this evening. So if they're watching, a big shout out to the lovely Miss Kristen, Megan, Shannon, and of course, Miss Winnie the Bulldog. And if you haven't followed Miss Winnie the Bulldog on Instagram or TikTok, well, you probably have a lot of better things to do. However, it is kind of fun, and who doesn't love Miss Winnie the Bulldog type of stuff? That's for sure. So anyway, for those of you who've never joined us before, maybe this is your first time. My name is Scott Reich. I'm a practicing criminal defense attorney. Have been practicing criminal defense primarily for the last 26 years. It's a long time. But hopefully what I bring with that experience is to give you straightforward legal analysis of cases that are obviously popular, that people are watching, and give you an analysis that you don't often get, for example, like on the evening news. That was one of the reasons why we started this channel, was because I was so frustrated during the Chris Watts era that basically nobody knew exactly what they were talking about on the evening news. They didn't know the difference, but what the next court appearance was, what it really meant, what was going to take place. No clue. So I put up a little channel. Next thing you know, I put up a video, and boom, it took off. And now I think we're just over 185,000 subscribers. Perhaps we'd be a little higher if we engaged in a lot more speculation, but we do not want to do that. And frankly, calling me a little skeptical of a lot of theories, whether it comes from the government or, I hate to say it, even fellow YouTubers. Now, we'll get there in just a minute, but I want to give you an example of something that has taken place. And I think Frank has it queued up, because although Julie went back home to see her family on the East Coast, Frank is still there in the Crime Talk studio, the hardest working man in show business, making sure that this all works flawlessly, hopelessly with good sound, because the room that I'm in, the little office center here, it's a little echoey, so I hope it's not echoey at home. The other thing is, we don't ask for super chats, but if you have a question, they're more than likely going to get answered because they've been highlighted. That's it. Sometimes the chats get rolling really, really fast. But super chats that kind of pop to the top, and I will try to answer those the best of for everybody. All right. let's see here. I'm just looking here at a couple of chats here, but all right, so let's get started. Obviously, still a lot in the news. We talked about a question today on the show that was asked regarding Mark Means, and it came from a subscriber basically saying, hey, what does this mean? I looked at the link. This individual, I think, had no idea. I'm not sure what they understood to be, but they purported to have a conversation with Mark Means, and that there was apparently some documents that were released. The question then becomes, well, can you do that? Okay. And we talked about, the attorney-client privilege. And the attorney-client privilege is there so that people can actually talk to their attorney, tell them the truth so the attorney can give them the best advice. It is the same thing as when you go to the doctor. You expect to be able to talk about what took place, your medical conditions are, and that they're not going to be shared with anyone outside of maybe other medical professionals to assist you. And so you can't go about doing that unless you have permission from your client to do so. Now, of course, if you have a client that's not competent, I'm not sure they can agree to have you give information away, particularly to a YouTuber. And that would include documents that the attorney comes in possession of during the course of that representation. And those attorney-client privileges, the communications, remain privileged throughout the entire course of the representation and beyond. So if you had a client that came to you and said, hey, let me tell you where the bodies are buried, the attorney has to keep those confidences absolutely secret. You cannot reveal those. If the client fires you or they even die, once again, you still can't tell anybody, for example, where the bodies are buried. And that's just the way it is. And people say, well, that's not right. People should be able to know. What about the families? They need closure. I understand it, but those are the legal ethics that exist. Sometimes you don't like them. Sometimes you may not understand them. But in the big picture, they are there for everybody to have that confidence that their communications are private. Think about all the things people tell, their therapist, their priest. You tell them in confidence that no one else is going to repeat those. And when you start sharing documents, it gets tricky. And even more tricky is when you have a criminal case that is high profile and you think that you're going to manipulate the media, okay? And I know a couple of attorneys that say, hey, I will use the media to my advantage every step of the way, which is fine, but you have to absolutely be correct, okay? Because if you spin it the wrong way and something else comes out, it's going to bite your client in the butt. My general rule is if there's a case that's made to the news media or you get an inquiry from the news media, you don't call them back. And if you maybe call them back to say, hey, what's the story you're going to run? You at least have a heads up, but you don't make any comments. And you certainly wouldn't do it without communicating with your client. It's like, do you want me to say anything in response? My general advice would be to keep your mouth shut, because I've said it once and I will say it again, like many, many times. It's better to look guilty than to be found guilty. Bottom line there. All right. So I want to show you this video here. I want to put this up because there was a video that had gone viral the last couple of days. I think it was up in Milwaukee, and somebody was videotaping it, and the video gone viral, alleging that the police officer had planted drugs in the vehicle. Well, you always have to wait. You always have to get the facts right. We saw this video, and my first thought was, something doesn't seem right. Well, guess what? The entire body cam encounter was turned over. So, like I said, Frank, who is the hardest working man in show business, let me show you what he's done. First, there is the video from the individual in the car. Then you have the video from the police officer. get what didn't make it in the edited phone video that went viral. Oh, that's right. The facts from the body cam. Yeah, that was turned down. So Frank, go ahead and play this. And this is why it's so important not to get ahead of over your skis and have issues. Because let's say somebody's arrested. Oh my gosh, look what happened. And it turns out it's not exactly what happened. So you have to be patient. You have to be diligent in your research. You have to make sure you get the facts right. Because I saw this video over several platforms, and people were all saying, oh, look, the police officer was trying to frame this young man. Now, it would have been a lot better had the police officer not thrown it in, because why? Appearance is reality. Perception is reality. If people believe that, perceive that, let's face it, cops these days are in a tough position. They need to do it better and cleaner than the next guy. So Frank, if we've got that video, go ahead and roll it right now.
I got specks of green. You're good to search if you need to. Corner cut. What's what? What's what word?
I got you on camera, bro.
I got you on camera. We're all good.
Hey, bro, you just threw that in here.
Yeah, because it was in his pocket, and I don't want to hold on to it. It's on their body cam that they took it off of him, so.
You just threw that in here, bro. I got you on camera, man.
I'm telling you where it came from, so.
I got you on camera, bro.
It's an empty baggie at the moment, too, so. Okay, buddy.
All right, so you can see from the video that what went viral wasn't exactly the truth. And, it used to be that, a lot of people would say, particularly jurors, well, if it wasn't on video, I don't believe it. Well, now it's coming to the point where you're not even sure if the video is going to be accurate or whether it's been altered. Because the things that, for example, Frank can do with a green screen and editing and audio, it's unbelievable. And so now it's coming to the point where you have to be able to trust the video itself. You almost want to be able to see the metadata. How has it been altered in any way whatsoever? And so, this video, like I said, yeah, fortunately for the police officers in this situation, they had the other officers. I think there were some 6 hours of body cam, and it showed the other officer pulling this piece of saran wrap, which, let's be realistic, probably contained some sort of controlled substance. The officer had it, threw it in the back of the car. The other guy accused him of throwing something in the back of the car. But the guy's audio didn't include the officer saying, I put it in there, and it was empty. It came out of that guy's pocket. It's on video, so bring it on. Of course, the video went viral. The police have to release the other 6 hours of video to show that the officer was in the right. So probably would have been cleaner had he not thrown it in the back seat. But the reality of it is he did nothing illegal whatsoever. But that's the perception, and that people jump out of there. And that's why hopefully on this show, this channel, we try to bring you the facts, because there are so many people, just like there are attorneys out there that will tell you exactly what you want to hear so that you hire them, and then they'll say, okay, fine, maybe later down the road, well, you didn't tell me everything, so therefore my opinions has changed. Well, you don't make promises that you can't keep. And like I said, I'm not throwing stones at anybody, but let's face it, there's a lot of stuff on the internet, on YouTube today, particularly about a lot of these cases out there where you scratch your head and say, how are these people doing this? And if the individuals had somebody that could go after and, sue them, they probably would. A lot of these people are overseas. You can't get to them. They have no money to sue them, but they're really just spreading lies. And you don't have an absolute right to say anything you want, particularly if you know it's false. And there's so many people that do. All right. That's Scott's soapbox for this evening. It's just, there's always two sides. And I think everybody these days kind of they try to jump to conclusions that are not necessarily there. And it's just, it's bad news. And like I said, if Mark Means is talking to YouTubers and he thinks that he's going to somehow influence the case by releasing some information, wrong way to go about doing it, particularly when your client is in this current state been declared to be not competent to proceed. So how can she give any kind of consent whatsoever? I think there's a real problem with that. You just don't do it. I remember I had a case years and years ago. I had the news calling and said, hey, did you get the video? I'm like, what the hell video are you talking about? And he says, well, you need to go check out this video. And sure enough, they produced it. We got it. And the news guy hadn't seen it in person. He'd only heard about it. He received the information from a tip. Ultimately, when the case was resolved, the video was turned over to the news media with the permission of the client. And it showed exactly, it was full length. It was at the point where it hadn't been modified in any way. But if I had done that on my own, I could have affected my client's case very negatively. And who would they have blamed? They would have blamed me, right? Years and years ago, this was years and years ago, I did that case. It was on in the jury room, and ABC News got permission from the Colorado Supreme Court to follow the attorneys around in preparation for a case. In this particular case, it was a child abuse resulting in death case. I think we actually have it up on one of our videos. And then they watched the deliberations in the jury. They had the consent of it, and it was edited out, and what have you. And my biggest concern throughout that wasn't that I was not going to do a good job for my client, but she was looking at a lot of years in prison. And if I had lost in the sense that she had gone to prison in that particular case, she was ultimately found guilty of a misdemeanor, and she got county jail time, which is much different than a felony and prison time. My first thought was the first thing that the post-conviction relief counsel would have said was, you're just out there showboating for yourself. And, Exhibit A at the post-conviction relief hearing would have been the ABC News in the jury room, video. So you have to be very careful. I know some people that think there are masters of the media, that they can manipulate it, but it's come with a lot of experience, and they know what they're doing, so to speak. Usually when they have all the information, they're using it kind of to get some resolution or settlement. But to just go out there and to start communicating with people that you've never met, you've talked about online or on the phone, and next thing you know, and in today's world, you must assume that if somebody calls you and you're talking to them, you must assume that it is being recorded. And there's a lot of YouTubers out there, let's say, don't have the it's what's the word I'm looking for? And it's often in today's world, there's a lot of questions regarding the integrity of journalists, but you just simply have to, you have to assume that they're not your friends. That's just the way it is. All right. We have a chat here. Lions winner, can/will someone bring a case against Chandler PD for negligence in averting further murder by not arresting Alex nor testing for residue? Good question, Lions winner. I cannot think of a cause of action that the police could be brought forward for. I mean, first of all, remember, states and the government in general, they have immunity, and they basically, you'd have to show that a case would have to be brought on behalf of, say, Kylie and JJ. You'd have to give somebody that standing to say that, one, they didn't do their jobs. They violated their civil rights, so to speak, in 1983 action. And that, that but for this, these children would be alive. Now, I think that people could say, well, gee, it would be nice. I mean, I think I've said, wow, if the police had possibly done a thorough investigation, we wouldn't have had this particular issue, maybe Tylee and JJ, in regards to the Lori Vallow matter and Chad Daybell matter, and Tammy as well, would still be with us. But there's no cause of action that I can think of where somebody could bring that and reasonably win against the state. I think it would be thrown out. First of all, like I said, the state has immunity, all right? You have to basically have permission to sue the king, sue the state. They have to have a waiver of sovereign immunity to do that. And to say that it was reasonably foreseeable that their rights were violated because of these particular officers, I think you'd have to show, basically you have to have a smoking gun email that basically says, hey, let's delay this case. I think these people are bad people. Let's just wait till something bad happens. That's not going to happen. So great question, Lion Swimmer, but yeah, simply not the case as it relates to this particular case. Let's see here. Yeah, someone has, yes, I'm missing Oshkosh. Yes, I am. For those of you who do not know, I've mentioned this before. Yes, I'm a pilot. I have a little plane. I love to fly. I didn't even know if Oshkosh was going to go this year. This has been planned months in advance, but if I wasn't here, I would have gone to Oshkosh. Next year, we will go to Oshkosh to the EAA fly-in. It's the biggest air show. It goes an entire week. Never been there. Watched a lot of it on video. It's amazing. Seen lots of stuff going on. Really would love to go there. So look at a question here. Can a YouTuber solicit their admin services to a defense attorney in a high-profile case and ask for legal documents? Yes. Yes. If somebody believes they have a good faith basis that documents exist and they can get jurisdiction over that particular person, then yes, those documents could be subpoenaed. Phone records, all that stuff could be brought in. And, we've seen this actually early on in the Means case. In the Lori Vallow case, I think it was Mark Means tried to subpoena reporters for the hearing that they were going to have regarding, I think it was misconduct as related that they were alleging against Mr. Wood, the prosecutor in this case. It went nowhere, right? Once again, there's certain things when you give something to somebody that's truly a journalist, not somebody just kind of sitting behind their computer, who's writing the documents and things like that, then they have privileges as well, usually by statute, that protects the news media from revealing their sources. But if you're not really a credentialed journalist, so to speak, it's very difficult to claim those privileges. And yes, those documents could be subpoenaed quite easily or obtained through law enforcement. You could have law enforcement on your front chair if they have jurisdiction. If somebody in, say, example, Idaho probably wouldn't have jurisdiction over somebody if they were in New Jersey to say produce those. They'd have to do it voluntarily. And I get it. I mean, lots of people want to get involved. Everybody wants to be a sleuth, and I think that there's some great things that go on the internet where people solve crimes where literally the police don't have the resources to do various research. The one thing comes to mind was that case about don't F with cats. And in that particular case, these internet YouTubers, sleuths, tracked it down and basically presented the case to the police on a silver platter. So that's very, very good. But when you start literally interjecting and start going to interview witnesses and talk to them, guess what? Now you've become a witness in that particular case. So you got to be very, very careful. And I'm not saying I know all the answers. I'm not an expert in everything in the world. But, it's one thing to get on and talk about it. It's another thing to say, hey, I'm going to go start interviewing witnesses and see what they have to say. There's no privilege there. You could be ordered to testify at minimum for an impeachment witness if they told you something differently than what they maybe previously testified to before. Who turned over those documents? How did they get there? And guess what? If the attorney's doing that, they've just become a witness, okay? As an attorney, when I go and interview a witness, do I just show up and say, hey, my name is Scott Reisch. I represent so-and-so. I want to talk to you about a particular case. Now, maybe if they're friendly, maybe if it's not a big case, but if it is a big case, and I say big, I say a felony case, let alone a homicide case, I assure you, I am taking an investigator. Why do attorneys take an investigator to have those interviews, even if the attorney is very capable of asking the questions and taking copious notes? It's so they don't become a witness in the case. If I go and talk to a witness by themselves and they tell me A, B, and C, and then when they get to trial, they don't say A, B, and C, they say D, E, and F. The most the attorney can do is say, well, do you remember talking to me on this particular date and you told me A, B, and C? The guy says, no, I would have told you D, E, and F. I don't know what you're talking about. Well, in that particular case, then you say, well, do you recall speaking with me on this particular date? Oh, yeah, I remember talking to you. Do you remember me asking these questions? Yes, I do. Do you remember saying A, B, and C? Nope, don't remember saying that at all. Well, do you recall I had an individual with me that day? Yeah. You remember he was taking copious notes? Yes, I do. Well, then you call in that investigator as your impeachment witness to come in and say, do you recall having an interview with this individual on this date? Yes. Who was there? Well, you were there. I was there, and the individual. Do you recall what specific answers they gave to these specific questions? Yes. What did he say? A, B, and C. Boom. Impeachment right there. If you don't have that third-party witness there, the attorney's now become a witness. And guess what? If you're a witness to the matter, you can no longer be the attorney on the case. You can't represent somebody in a case where you are a witness. So I think people just need to be careful. Lots of people have great experience and training, but you just have to be careful. You could find yourself in a world of hurt if you don't know what you're getting yourself into. And, that's just the way it is. A lot of people are very brave behind a keyboard. They say lots of things. Some of the comments that we get some days, wow, I just would be like, really? I bet you, would you say that to my face? Oftentimes, most of them won't. And that's the beautiful thing about going to court. And that's why, for the most part, I find, we do civil in my firm, but I don't do a lot of it unless it goes to trial. But the nice thing about about criminal work is you're usually going to court. You know that you're going to see these district attorneys again, and you have to be polite. For some reason, I don't know why, but civil attorneys they're always so damn rude and mean. And then when you show up to court, suddenly they get real nice because they think you're trying to schmooze them. Like, well, you're an ass behind the keyboard sending me these nasty emails and letters. And now you want to be nice to me? Like, those days are done, my friend. Game on. Let's go do this thing. Well, why can't we? Well, like I said, everybody is a keyboard warrior, but they want to do it anonymously, and nobody wants to have the repercussions of what comes with it. So when somebody leaves a comment, whether it's here or anywhere else, you have to say, the first thing you do is look at the screen name, and if they don't have their real name on there, you just kind of think, okay, whatever. Let's see here. Question: at this point, would it be better for means to be removed to avoid any appeal based on representation? Interesting question. I don't know. Because frankly, I'm not sure if he actually did what he said he was supposed to have done by talking about somebody on the case. I hope he didn't do it. I hope that he would exercise better discretion. And like I said, I don't have anything personally against Mr. Means. I think he's inexperienced in this arena. He was primarily a divorce attorney, and it is a different world in the criminal defense arena than it is with divorce law. And I think that's very simple, just the way you see everything. In the civil world, it's all of this gotcha gaming. How do I get the other side, kicked off? And we're going to do this, we're going to do that. And it came early on when they were trying to say that the district attorney was engaging in manipulation and tampering with a witness. And we have that entire video, that audio up. We've done a video and we talked about it. My first thought was, under what circumstances does he think, Mark Means, think that this was tampering or manipulating with a witness in any way? None whatsoever. And guess what? They had the Idaho State Bar. They had this lengthy hearing, which should have taken about 15 minutes to resolve. It went an entire day. We thank the state of Idaho for that. And because it's good content, right? But it was the whole, there's no there. There's no burger there, no Whataburger, whatever it is. There's nothing there. But they tried to make a big deal out of it, and it fell flat on its face. And that's where I became not a big fan of Mr. Means, because he just, what are you trying to do? You think this case is going away, even if you thought that was the case? No. You think you're going to get rid of a DA? They're just going to bring in another one. Go try your case. If you think your client is innocent, you think you have a defendable case, even if you think you have a crappy case, make the government go prove it beyond a reasonable doubt. But quit playing games. And the other thing is, civil attorneys, they want to try their entire case in the pre-litigation discovery. Oh, we're going to get all this deposed people, blah, blah, blah. Let me tell you a story once. I'm sitting in federal court one day, and a very experienced federal judge is there. He used to be in state court. And, I showed up. I had what they call a change of plea hearing. My client previously entered a plea of not guilty, which is very routine in federal court. And then when you say, hey, we want to plead guilty, you file a change of plea notice. And it's federal court, and you know that federal court starts on time. And the other thing you learn when you go to federal court is not only does it start on time, you show up early. And I always like to show up early because I live by the principle. I hate being late, and I hate when we start these late. But it's usually my fault, so I apologize. But the old adage, early is on time is late, and late is unacceptable. So you're ready to go. And there are all these attorneys in there. It was a big civil case. And they had probably 5 attorneys on the plaintiff side, another 6 on the defense side. And they're saying, we need to have 18 depositions. And both sides have to have 18 depositions. And the judge is just sitting there scratching his very bald head at the time. And he's like, why do we need 18 depositions? Well, Judge, we need to find out. We don't want to limit ourselves, blah, 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 blah. And the judge says, and he points to the prosecutors and the defense attorney sitting in the back. And he goes, you see those attorneys? The first time they ever get to talk to somebody that's made an allegation is on the witness stand. Why do you have to have a deposition? Why can't you just go out and have an investigator interview somebody and see what they have to say? Why does it have to be a formal deposition? Because the judge also has a duty to limit the size of the case and control costs as well. And, those attorneys are thinking, well, we got to litigate. We're going to wear the other side down by taking all these depositions. The other side's going, oh, we're going to wear them down and we're going to bill hours and then we'll solve the case right before everybody puts a lot of money into it when everyone's earned what they think they're going to get, and we'll settle it. And that's the real problem I have with civil litigation. You file the complaint, you file the answer, you get the disclosures. Here it is. Then you ask interrogatories. Then you ask, you set depositions to go over the discovery and the interrogatory answers. And it just drives me nuts. I could have tried the entire case in less time than it took to fill all the damn paperwork and format it. So I hate civil work in that regard. Criminal case, I got the discovery. Let's go. You didn't turn it over. You're not going to be able to produce it in court. Let's go. And it's just, the point is you are just, what's the word I'm looking for? You got to just go try the case. So quit trying to try everything in the civil, because that's where Means was trained. I'm going to take depositions. I'm going to call them nasty names and say they're unethical and they're committing grievances, blah, blah, blah. That's what they do in the civil world. I see it all the time. Every time I take a civil case or the civil contempt, and I think I'll never do one of these again, and someone says, no, please, I got to have you. And you go, and it's the same thing every time. You think, next time I'm not going to do it. Or the retainer will be $1 million to deal with all the frustration that goes with all of that as well. So, Mr. Means, he needs to just go try his case, right? Get his client confidence. Although, we've all seen reports that he is visiting Lori Vallow nearly every day at the state hospital. I've never seen anything like that. I can tell you that. I've had many a client over the years sent to state hospital. I've had many attorneys in my office that have had many clients sent to the state hospital. And I've asked them, how many times did you ever go down to the state hospital and see if the doctors were doing their jobs correctly? Never. But yet he apparently goes down there and checks on her periodically, if not daily. I just don't understand it. I don't know why he's doing that. It's just weird to me. So there we go. Let's go back and see if we have some more questions. Like I said, if you haven't done so already, please hit the subscribe and like. We appreciate that. Okay, Lions Room had another question. Given all the witnesses, investigations, and moving parts in this case, how long might trials go? Sheesh, enjoyed the Pretty Lies and Alibis vid. Well, hopefully y'all enjoyed the Pretty Lies and Alibis conversation that we had the other day. She's great. Fruit Loop wasn't there, but it was very, very good. And they're interesting ladies, and they have a background in doing some of this kind of investigative journalism, and they try to keep it to the facts as well. And so that's why I like them. Good podcast. Go check it out. I haven't looked to see if their numbers popped up, but hopefully they have. They're nice people. Question: how long could this trial last? I believe the Chad Daybell trial is now currently set for 3 to 4 weeks. I think there was some sort of break or short week, so it's 3 to 4 weeks. In a case like this, I think that is sufficient time for the prosecution to present their case. The defense obviously won't need as much time, but they'll be able to potentially bring in information that they deem necessary and relevant through the prosecution witnesses. So I think that the 3 to 4 week time frame is going to be enough. The biggest mistake any prosecutor can do is to over try the case. All right. Pretty simple, straightforward case. If you think about it, they just need to lay it out correctly. Obviously, lay out the little roadmap in opening statement. This is what you're going to hear. You're going to hear Lori Vallow. You're going to hear about her kids. And basically, the timeline when she met Chad, kids go missing. She goes off, no concern in the world, to Hawaii. People asking, where are the kids? You would think my kids disappeared. I would be searching anywhere. They were pretty chill. In fact, they were getting married, having a honeymoon. I think a lot of people would say that's weird. And then the fact that they find, the children's bodies on the property of Chad Daybell, big problem for the defense. No, that's not good. I mean, that's what, half day. You bring in the police officers that took the initial report. Maybe you bring in a family member to say, we were concerned we didn't see JJ and Tylee. Okay, that takes a day, maybe. You just kind of go through the timeline. You keep it simple, all right? The biggest mistake a prosecutor can do is to over-try the case. Hate to tell too many war stories, but let me give you an example of that. Had a case years ago, simple little case. It was a fight at a quinceañera, all right? If anyone's ever been to a quinceañera, I've been invited to a couple quinceañeras, only attended one, but had many a client invite me to a quinceañera. And, when you're kind of the family attorney, so to speak, they invite you. And anyway, so if you go to quinceañera, there's obviously a lot of dancing, a lot of proud parents, and lots of guests. Lots of guests partaking of alcoholic beverages, which tends to cloud individuals' judgment from making good decisions. And then what do? That's right. They usually engage in some sort of altercation, usually fights. So needless to say, I wasn't at this quinceañera because then I would have been a witness, but I wasn't there. So simple little fight at a quinceañera. Our defense was, yes, there was a fight, but my client did nothing to do it. Now, had the district attorney called one witness and said, do you see the bad person that punched you in the face? Yes, he's sitting right over there at the defense table. Pretty straightforward case. What's the defense? Well, he hit you first. Nope, had to put your client out. But the district attorney kept calling more and more witnesses because they think more is better. Sometimes less is more. Remember that. Less is more. And what happened? They called all these witnesses and they started getting all these different stories. And I cross-examined on this, and my God, there was some more confusion going on after I was asking questions. It was beautiful. I loved it. The district attorney gets up in her closing statement, right? This is where she's going to get up and say, we've proven our case, find the defendant guilty, and this is why you should do it, blah, blah, blah. Let me show you the checklist. This is prove identity, location, bodily injury. She gets up and says, well, we may not exactly know what happened here, but we do know there was a fight and somebody suffered bodily injury, pain, and therefore find him guilty, the defendant. And I remember looking at the judge, and she kind of cracked this little smile on her face. And I got up in a very brief closing statement and said, ladies and gentlemen, please find my client not guilty. And let me tell you why you should. It's simply because the district attorney has said you should find him not guilty. The DA objects. It's argument. You can continue. She said, we may not know exactly what happened. Well, guess what? If the prosecution doesn't know exactly what happened, how do they expect you to? And therefore, guess what, ladies and gentlemen? That equals reasonable doubt. Not only did the jury come back and find me not guilty, one of the jurors came and asked for my business card for a family member that was in trouble. So the point is, if you're a prosecutor in this case, don't overtry it. They have 3 weeks probably for the prosecution case. That's more than enough time. Yes, there's going to be witnesses, a lot of witnesses. Yes, there's going to be officers from other jurisdictions, primarily FBI, the phone people to talk about various search warrants, and records people from Google and iCloud from Apple to talk about how they maintain their records and things of that nature, location data. That's going to come in. And then they're going to have the arrest. She's in custody. Chad Daybell is at the property as they're executing a search warrant. And that phone call where Lori Vallow calls Chad Daybell and says, "Hey, what's going on? They're searching the property." And we've got that phone call up, so you have to take my paraphrasing of it here. Yeah, they're searching the property. And it's kind of like, oh, okay, well, call me later if you can, thinking, well, that's not good. You're probably going to be arrested. And Chad's like, yeah, I'll call you if I can. Ooh, that's really not good, right? So then what happens? He drives away. They find remains, and he's arrested. Bam. End of case. You have dead bodies on that property. Now, the prosecution may want to get into this whole zombie thing and the dark spirits and what have you. But still, don't overcomplicate it. The reality of it is Lori Vallow, Chad Daybell, together, children missing, remains found on the property. It doesn't take that much. Now, the prosecution has to prove, and they'll have to show that it's a conspiracy. So even if the defense says, well, I didn't do it, Chad Daybell says, I didn't do it. If they can wrap up that conspiracy, you're guilty just like you did it. You're, in for a penny, in for a pound in a conspiracy. So the prosecution, in this case, my advice would be, just from a defense perspective, keep it simple. The more evidence you put on, the greater chance the defense can create doubt. You get one person up there who says, I don't really know. And you just never know. Sometimes I've had some of my best arguments come from something that came in trial, and it just kind of developed as a theme, because basically, for lack of a better term, I didn't have anything, but we created something by people getting up and testifying about usually things they didn't know about, and they speculated. And you're like, well, that's not right. And you bring it up, and guess what? You're creating doubt. So my advice then would be, keep it simple. My advice for the defense would be, keep it simple. Chad Daybell's defense is going to be very simple. I didn't do it. There was no conspiracy. My God, those children were on my property. I'm just as shocked and surprised as you all were. What did this crazy woman and her brother do? Well, I was not aware of things, right? And we've talked about this, all those text messages, things like that. You have to put the person behind the phone to do it. You have to establish the conspiracy. Maybe this is getting too far in the weeds, but it's called a James hearing, James proffer, okay? And it's a federal case. Supreme Court basically say one of the exceptions to the hearsay rule, right? We've talked about this quite a bit. Exception to the hearsay rule is there are statements made in furtherance of a conspiracy. That's one of the exceptions, because, right, if it's hearsay, but all the statements are made to go do bad things in the conspiracy is simply an agreement to commit an illegal act. That's all you have to show. But it'd be hearsay otherwise, it makes it difficult. So can't make it difficult for the prosecutor. So what do? They say, hey, we'll create an exception for that. And if you are in a conspiracy, everything you comes in as long as it's in furtherance of that conspiracy. The prosecution simply has to show by a preponderance of the evidence, not proof beyond a reasonable doubt, but a preponderance of the evidence that a conspiracy existed. Then the prosecution has to show that those statements are admissible, i.e. in furtherance of the conspiracy. And then they have to be able to identify under what theory or exception they're going to get him in. And then they also have to be able to bring a witness to say what somebody said. But in this case, we've talked about this, the electronic data stuff is not that easy. It is not that easy, and it gets more complicated, which goes back to keep it simple. Keep it simple. People are expecting a 3-4 week trial, and the prosecution can roll in there, present their case in 2 weeks, jury's going to say, wow, they nailed it. They nailed it. We're in and out. You drag it on, the more likely you have ways to mess things up for the prosecution. All right. Hopefully that answered everybody's questions. Let's take a couple looks here at questions. Quiet night on questions. Now, for everyone tonight that wants to continue on, we'll have our Patreon show immediately following this for our Patreon members. Unfortunately, won't be able to have a call-in show tonight because I think Frank has amazing technical skills. I'm not sure that he can get the phone set up so that I can hear everybody down here. But you never know. Maybe he can. Well, if there's anyone that can figure out, it's Frank. Let's take a look at this. If the patient admits continuous threat. Oh, okay, good. Now, so see, this is why I love this. This is great. Somebody said, Scott, I'm a physician. Major exception to the doctor-patient confidentiality. If the patient admits to constitute a significant threat / intending to cause harm either to themselves or others, I'm going to go do bad things to my wife. The physician cannot keep that to themselves. Public safety takes precedence. Are there similar legal exemption clauses? Yes, there are. All right, great question. I think it's Thomas is M. Thomas, THOMISOM 101. Yes, good question. If the client comes to you and says, hey, I just did a very bad thing, let me tell you where the bodies are buried. That is attorney-client privilege. If the client says, hey, I just did a bunch of really bad things, and oh, by the way, here's the knife, here's the weapon that was used. Guess what? Attorney cannot destroy that. They actually have to call the authorities and simply say, I have this item, here it is, do with it what you must. That's it. If a client comes to you and says, hey, you know what? I want to hire you because I'm on my way to do a very bad thing to some people, the attorney at that point, if it is a reasonable threat, they truly believe that this person is intending to go do something. And I'm not talking just venting. I'm talking like, here, let me show you what I'm going to do to this person and how I'm going to do it. Here's the instrumentality of it. At that point, if you truly believe that there's something that's going to be harmed, then it's going to be harmed. Yes, the attorney has an obligation to do that, just like a doctor would if there is an imminent threat or harm coming their way. Oftentimes hard to distinguish. I remember the James Holmes case. He was seeing a therapist. I don't remember if it was a psychologist or psychiatrist, but apparently there were some concerns. And then bottom line is that, what did the therapist say in that particular situation or didn't? There was a bunch of litigation. Is it privilege? Is it not? So it's a tough call. And the James Holmes was the Aurora Theater matter. So it's a tough call. Oftentimes you have situations where clients are like, oh, I can't go to prison. I'm going to harm myself. I'm going to do this, blah, blah, blah. Are they serious about it? Are they just doing it to look for sympathy? Maybe think, well, if I'm concerned, can we, will help me get a better deal if I think I'm going to do that? My general experience is clients that are truly going to hurt themselves don't call their attorney. I've had several attorneys or several clients over the years that have hurt themselves. And they never called me beforehand to say they were going to do it, which is good. So I didn't have to deal with that particular situation. I once had a situation where my client was at a standoff and the police called me because they wanted to talk with me. I spoke with him. Next thing you know, you hear some bangs and the police start taking down their command center and like, oh, it's over. You can just go back, have a good day. Thanks for coming down. And you're literally like, okay, I got called out of court. I rushed down here today. Just spoke with my client, who apparently is no longer here. Guess I'll go back to the office and get some work done. You know, it's a weird situation for sure. So yeah. So anyway, so that was a great question. See, we have great subscribers, smart people. See, we have smart people that subscribe and watch to our live show here on Tuesday night. So thank you. Appreciate it. Great question. All right. Can you believe it's already been an hour today? Yes, it is an hour. So it is our time to leave, but if you would like to continue on, we'll see you on the Patreon side here shortly. And if you haven't become a Patreon, join. So join, time to join, sign up, go to Patreon, CrimeTalk_Scott_Reisch, and you'll get the magic link and you can join us later. And Frank has told me, yes, he'll be able to get the call in as well. The only thing he won't be able to do is do the magic 8-ball because I don't have it here behind me because there is no Crime Talk studio and no magic 8-ball this evening. So, all right. I want to thank everybody for tuning in. Please join us for our Patreon show shortly after this. Give me just a couple of minutes. Have a wonderful night. Thanks for watching.